this warrant requirement, we've talked a bit about automobiles. Mm-hmm. Automobiles are a really unique and difficult area. Tell us a little bit about that.
Well, I think that is a possibility, right? So this is a legal question, and questions of law are determined by the judge. Questions of fact are determined by the jury. In this particular instance, an analysis of the Fourth Amendment to a particular search or seizure is something that the judge has to apply the law and determine what is.
There's freedom has consequences, right? Every right that we have in this country has negatives, right? The First Amendment causes a lot of harm to people with some of the speech that's out there. The Second Amendment, of course, but the Fourth Amendment, there will be victims. But the way I look at it is that I want to, when I teach these cops, I let them know sometimes, hey, don't forget, like, whatever you're doing out there, you have to live in this world too after you retire. So if you get stopped by police, are you okay with
the right of the people to be secure in their person, houses, papers, and effects against unreasonable search and seizure shall not be violated, and no warrant shall issue, but upon probable cause supported by oath or affirmation, and particularity describing the place to be searched and the persons or things to be seized. That is the text of the Fourth Amendment, and we're here to talk about it today. I'm your host, Scott Coffey. For those who don't know me, I've been an attorney with the Clark County Public Defender's Office for 25 years, and I now supervise the homicide unit at that office. I am joined by two gentlemen who work regularly with search and seizure law and the Fourth Amendment. They are Mike Dickerson from the Clark County District Attorney's Office, who has been an attorney there for almost a decade, and Anthony Bandiero, who works with Blue and Gold.
Yep, the company's called Blue to Gold Law Enforcement Training, and we focus primarily on search and seizure training for cops around the country.
So I began by reading the text of the Fourth Amendment, and that is a pretty thin amount of text.
Yep.
Is it easy for courts to interpret, for people such as yourself to train on the text of this?
No, I mean, so the way I go, what I start off with is that these are 54 words, and those 54 words control essentially 100% of government behavior. And it only prohibits one type of search or seizure, the unreasonable one. So the challenge is, what is unreasonable under the Fourth Amendment? And so I have a framework that I teach cops to try to apply in the field because it can get a little nebulous, but that's the challenge, is what does it mean to be unreasonable? And of course, I think we all can agree that people matter, the Supreme Court matters, the Ninth Circuit matters. I mean, these are all things that are somewhat in flux,
And to date, I believe that the Supreme Court, since this Fourth Amendment was enacted, and I think it was 1792 approximately when it came in to fruition and took effect in the United States, has issued about 230 plus decisions regarding the Fourth Amendment. And so we're at a point where we've seen that Fourth Amendment and the way that it's analyzed change over time, right? And it initially, for a long time, up until the 1960s, was under a theory of trespass. And common law theory is a government official trespassing upon your land or upon your property. And then in the 1960s, we saw a real shift to this reasonable expectation of privacy in addition to the trespass theory, which has guided courts.
You bring up a good point. I mean, this is from the federal Constitution, but it's applicable to states, right? Following a decision called, I think, MAP versus Ohio in 1961, that they said it applies to state agents also. But when it's written in context, James Madison, the other founding fathers that are behind it, are concerned about Brits boarding in their homes and seizing their paperwork and that sort of thing. But the context is very different, right? I mean, they didn't have an idea about automobiles back then. Maybe carriages,
they had
I suppose.
ships. Yeah, they had ships and carriages, right?
Yeah, ships and carriages, but this mentions specifically homes.
Yep.
Cell phones were not considered. I mean, all those kind of things. How does that present a challenge?
I mean, massive. And one thing just comes to mind is this third-party doctrine. For the viewers, this third-party doctrine is this idea that when people hand over, I guess voluntarily, right, their information to other people, other companies, then that company can hand over that information to the government without any hesitation, any legal issues. But those cases really come from the 1970s, where the world was a lot different. The pen register, when the numbers you dial on your phone, or your banking records. But that was a cash society. Now it's cashless society. If I could get a hold of your debit card records, debit and credit card records, I could pretty much know everything about you. Not everything, but certainly a lot. And so that's the challenge. I think that's one of the biggest challenges in 2022.
Yeah, our framers could have never imagined where we are today, right? But thankfully, in the Fourth Amendment, what they've included is person, papers, houses, and effects, right? And so effects is now, it takes part in a lot of things. I mean, cell phones are one of your effects.
You got me a little concerned with this bank records issue. Can you just ask the bank for my bank records and get whatever you want? Is it that easy?
Constitutionally, yes. If obviously there's laws and there's policies, and a lot of banks are not going to do that in this day and age, I don't think. But absolutely, if a government agency wanted to ask your bank for your records, they can hand them over, and you cannot, right now, you cannot really do much about it constitutionally.
So generally, bank records would be received by court order or subpoena, and that comes into play where a search warrant that is premised on probable cause is not needed. And so that is really the effect of the third-party doctrine, where you're providing your information to somebody else and they're holding it for you, and now that information is the bank's, and you don't know what they're going to do with it. They use that throughout all their business, and so the government can come in and take a look at that.
Can the government demand it?
No, I don't think so. Not without a warrant.
I believe that they could get a court order for it, and they can subpoena it.
Right, with a subpoena.
Right.
They can demand, right, with some.
But a court order isn't as easy as asking, right? There's more that goes into a court order. What would that be?
So what goes into a court order would essentially be some sort of reasonable or articulable suspicion to believe that there would be evidence of some sort of crime located within these bank records. So you can't just have some police officer just show up to Nevada State Bank and say, hey, I'd like to see these records. That's not going to have any legal force. But if there's a subpoena attached to it, or if there's a court order attached to it, then yeah, absolutely, they'll turn those over.
So with that court order, when we're talking about some kind of reasonable suspicion or probable cause, and I think probable cause is the language that they use in the Fourth Amendment, actually, right?
Right, so probable cause would be the higher standard required for the search warrant, but reasonable suspicion for an order to issue for those records would be sufficient.
So what does that mean? Let me give you an example. I look like I do too many drugs, or my suit is nicer than my salary. Can you just say, he looks like he's spending too much money, please give me his records? Is it that simple, or does it require something more?
I don't think that would be reasonable, right? I think it would fail on that prong, that Mr. Coffey's suit looks so nice, and I'm just not sure how he's making that kind of money at the public defender's office. That's not nearly enough, I would believe, because when you actually pull back the curtain on it, yeah, I think that you can absolutely afford a suit that's that on your salary. So you'd have to have something that actually tends to indicate that there might be something there.
Something criminal.
Something criminal, right?
Something criminal, some reason to look.
Some reason to look, beyond just, hey, I'm curious.
Okay.
And hunch, as we'd say.
Now, the text of the Fourth Amendment mentions homes specifically. Is there anything special about a home, say, compared to me walking down the street or driving my car or that sort of thing?
Well, the home is the most protected, the area under the Fourth Amendment. In many ways, your home is more protected than your body. There's all kinds of things that police do to people. Searches, search incident to arrest. They go to jail, maybe in some cases a visual cavity search if they're going to put that person into the general population of jail. That's pretty intrusive. I mean, to me it is. But you can't step 1 inch into a person's home without that person's consent, without a recognized exception that's based on some form of exigency or a warrant. And the home is it's a castle, right? So it's the most powerful and most protected area in the Fourth Amendment, without question, in my mind.
And that goes back to just the history of the Fourth Amendment, right?
Right, exactly.
Yeah, what we came from in the 1700s, and England.
Why are we here? Yeah.
Right? Why
Yep.
we're here is that, in England, a case that is often cited still to this day in the U.S. Supreme Court case law is Entick that came out of England, 1765, where at that time the king had a man named John Wilkes who was upset with him, right? And he was a member of parliament. He was a radical journalist, and he's writing all these papers, and the king doesn't like it. So what happens? The king and the Secretary of State get together and issue these general warrants for Wilkes and then all of his friends, including this guy Entick. And they go, and these general warrants, essentially what that is just, it says, hey, you can search anywhere for anything that you want that has anything to do with this, right? And ultimately, in that case, Entick, the court in England came down with the decision that there were multiple issues with it, right? Is that this wasn't something that was subject to probable cause. This wasn't something that was subject to specificity to only search and seize criminal documents, right? And specifically allowed them to go into people's home. And in that case, the indication was that that was absolutely against everything that their civil society and their laws stood for, because the home is the castle. And so we've come to a point now where it's not just the front door, right? Coming in the front door, it's the immediate area around the home as well that is protected.
Explain that.
So the concept of curtilage, the curtilage of the home as it's called in the law, is the area that's immediately around the home, and that's too protected. So it's not just that a police officer can come up to and not enter the front door. They also can't necessarily come up and search around the house.
Be in your backyard.
Yeah. A more recent case, right, indicates that a police officer came up and there was a vehicle parked in the curtilage of this house right there next to the house on the property, and he came to do an inspection of that vehicle, and that was deemed to be unlawful. Though there's other case law, including Florida v. Jardines, where the Supreme Court has found that a dog coming up, a police and their dog coming up to the front door of a home.
A drug dog.
A drug dog.
That dog, that canine, and I think we're talking about the same thing here, right? The bringing up, the officer could come up to the front door.
Right.
But once he brought his canine friends, that transformed that knock and talk into an intrusion under the Fourth Amendment.
Right. Yeah. And that the officer himself has the general license, just as the public would, to come knock on the front door. Right. But beyond bringing the dog or having some device that can look into the home or sense the home.
Is that universal, though? Suppose I put up a gate that says no vendors, no, I don't want to be disturbed, stay out of my yard, no trespassing, that kind of thing. Does that give me more protection?
It can. In the Ninth Circuit, so generally speaking, no trespassing signs, that's what really comes up. No trespassing signs in and of themselves do not prohibit police from knocking on the door. It's just, I think no trespassing signs have other meanings. Hey, don't come to my house at 2 o'clock in the morning. That's trespassing. Don't come to my house and scope out my windows. But coming to my house to talk to me about something that's going on is not necessarily trespassing. That's how I look at it. But in the Ninth Circuit, if you had a no trespassing sign on the front gates, the gates closed, that could send a message that this person wants nobody in their yard.
So there's no general license.
There's no general license. The license has been pulled.
So the officers don't have a right to be there is essentially what we're saying in layman terms.
Maybe. Yep.
Possibly.
And that's kind of the standard for whether they can go to a door or not, whether they have a right to be there like anybody else. Is that essentially what you're saying?
Yes, but I want the viewers to also understand that what we're talking about here is these knock and talks. Clearly, a no trespassing sign or police officers keep out is not going to keep a cop out investigating something that's ongoing, like an emergency, a domestic violence, a medical issue, a burglary, in progress burglary. So obviously those are going to be different, but it would.
You used a term earlier, exigent circumstance.
Right.
And that's what we're talking about here, right? That's a fancy legal term, but it means some kind of emergency.
Some kind of urgency, emergencies. We don't have, the officer would not have time to stop what he or she is doing and go get a judicial pre-approval for what they want to do.
Okay, so a warrant wouldn't be practical.
Correct.
And the Fourth Amendment talks about these exceptions. It says shall not be violated, but again, you mentioned at the beginning, I think it's reasonableness.
Yes.
And so the thought is that in some circumstances they are pressing, and because it is a pressing circumstance, it's not reasonable to get a warrant. and it gives you a little bit of leeway to do certain things.
Yes, but that only describes some of the exceptions, right? What reasonableness means under the Fourth Amendment, the way I look at it, and the way I train police officers, and I train Las Vegas Metropolitan police officers, is that in order to be reasonable, you're looking for three things. And in other words, if you do a search or seizure, and we can always talk about what that is, I think it's actually a fascinating conversation.
Yeah.
But if you do a search or seizure, then to be reasonable, you need one of three things. You need the person's consent to search their car, for example. You need a recognized exception. Some of these recognized exceptions are not based on exigency. The motor vehicle exception, for example, is not based on exigency. I mean, in the old days it kind of was, but today it's not really legitimate exigency. Or you need a warrant. So if you have one of those three things, you are reasonable in my view, you're reasonable under the Fourth Amendment. If you do not have one of those things, then you have a problem.
What if the warrant, coming back to our earlier example, is, Mr. Coffey doesn't dress appropriately because of his station. And the warrant is kind of clearly, we can all agree it's not a very good warrant.
Mm-hmm.
We all ought to know better. But you, being the friendly officer that you are, decide to act on the warrant.
Correct.
What happens then?
Well, I mean, I'll just give my 2 cents. So there is this idea that warrants can be so facially invalid that no reasonable police officer would read this affidavit, read this warrant, and say to him or herself, yes, this is good. We can do this. And that's the example of, going after you because of the way you dress. That's facially invalid, right? And courts are not going to reward a police officer because, there are rubber stamp judges in this country. And what that means is that there are some judges out there that, for whatever reason, they will sign warrants pretty easily for police officers. Some judges are not even lawyers, right? So they just sign it, and then we litigate it later. And so it can be so facially invalid that it causes issues.
What if it's not necessarily facially invalid? The officer thinks that it's good, but a court later says, our friend, the justice of the peace, got it wrong, or our friend, the district court judge, got it wrong. What happens then?
Well, the officer can rely on good faith, and they had good faith to believe that this was a valid warrant at the time it was executed, so it could be valid. And so at that point in time, there would be no issue.
The way I look at it too is that the way the courts, you have your perfect warrant, probable cause, facially it's probable cause. Then you have these wobblers. You have ones that, they may be the judge. There's a case where the judge signed the affidavit instead of the actual warrant. We're not going to penalize the cop for that one. You also have something called arguable probable cause. This is where the probable cause is, the appellate court says, there really wasn't probable cause there, but it's arguable. There's a reasonable officer who would have thought there was probable cause. We're going to save those ones under good faith. And then you have the ones that should have never been issued in the first place.
And those ones that should have never been issued, a trained police officer should really look at them and be like, this is no good. And that's the one that's going to be penalized.
Right.
That's the one where there is no good faith exception.
That's right.
So how does this work with something? I mean, this gets to be very complex, it seems to me, particularly when we're talking about something like cell phone records or access to an iPhone, right, which are highly protected. How does the law deal with those sort of things?
Interestingly, right, I think that the Supreme Court has tried to keep it where it is clear so that police officers can handle this on the streets and know what is legal and what is not legal. But then the Supreme Court is just, the highest court in the land. There are so many other courts, all the circuit courts, all the district courts of the federal government, all the states courts, all the state Supreme Courts, all the states district level courts as we have in Nevada that are interpreting this law and interpreting the Supreme Court's decisions. And so I think that at that point in time, we do see some of these concepts become muddied from what they've been interpreted at the highest level.
You mentioned before we won't punish the officer if they have good faith. What do you mean by punish? Do they get fired? What happens to them?
Evidence. That's evidence. So if an officer, we're talking about the facially invalid warrant.
All right.
If we have a warrant that is so facially invalid, what the punishment is going to be, the officer is going to lose that evidence. So the exclusionary rule.
The exclusionary rule, so they can't go forward on the case.
Well, they can go forward on the case. They just can't, they just can't use that evidence. Maybe they have other evidence. Maybe they actually, but usually in the real world, the case is done.
They end up with a weaker case.
Very weaker case, if not, or no case, and the person gets released.
Have you ever dealt with cases like that where evidence has been suppressed?
I have never had one of my cases where evidence has been suppressed to my recollection currently here. What I've had is a number of cases where the evidence has been challenged, and we've had suppression hearings to determine the legality of the evidence, of the search itself. And there's a plethora of cases where evidence has been suppressed and evidence was taken illegally. I think that ultimately that is absolutely what the law should be, and it's right on point, is that if the evidence was taken in violation of the Constitution, and there's absolutely no way that that should ever be in front of a jury.
How do you square that with a victim, though?
There's freedom has consequences, right? Every right that we have in this country has negatives, right? The First Amendment causes a lot of harm to people with some of the speech that's out there. Some of the speech actually hurts a lot of people. Think Westboro Baptist Church, there's a lot of victims in some of the Second Amendment, of course. But the Fourth Amendment, there will be victims. But the way I look at it is that the Fourth Amendment is not just there to protect, and make sure people have a fair trial, but it's also to make sure that the innocent are also not illegally targeted, and they're not, they're not subject to baseless investigations. And I want to, when I teach these cops, I let them know sometimes, hey, don't forget, whatever you're doing out there, you have to live in this world too after you retire. So if you get stopped by police, are you okay with you getting treated the way you treat other people? Is that the kind of world you want to live in? Because one day you're not going to have that badge, right? So, and obviously, the students I train, the vast majority are the good faith. They want to do things right. There's always exceptions to the rule, very rare. But the point is we're on the receiving end of this too. It's my freedom too.
And as far as victims go, it's unfortunate at times, right? I think that's one role as a prosecutor, that you need to be able to explain to the victims what's happened so that they understand. And you know what? There's nothing that can be done at that point. If something was illegal or illegally taken and it's suppressed, that is what it is, unless the judge has made a bad decision and it's taken up for appeal and it's reviewed and overturned. But I think that that's the key within the criminal justice system, is just at least explaining, and they deserve that.
I think what I used to tell juries and people in our office is, if it's going to work for the best of us, it's got to work for the rest of us.
Yeah, I like that.
And that seems to be kind of the situation here, just like I wouldn't want, if there wasn't an exclusionary rule, you wouldn't have any stops, right? Is that, that's fair? You'd have a police state to some extent, or the potential for it.
Potential,
right.
Because you also have civil rights violations, but you can also, there's another mechanism, but yes, absolutely.
Right, yeah, so, and if that's all we had was a civil rights violation, then it really wouldn't matter, and that the Fourth Amendment had no teeth at all, because any illegally seized evidence could just be used against a person in their prosecution.
Yeah. Do courts take this sort of thing seriously?
Yes.
How would that work? I'm a defense attorney, or I'm a defendant. I like that role better. I'm a defendant. And you come into my house and you take something and I want to challenge why you're there. What do I do? What would my next move be?
So your next move would be to file a motion to suppress. And here in the state of Nevada, that's something that can be handled right away. As soon as a case comes to fruition and gets filed in the Justice Court, which is our lower level courts that first get felony and gross misdemeanor cases to hold a preliminary hearing to decide whether it even goes on to the district court to get set for trial. And here, as of more recent case law as well, those justice courts can handle those motions to suppress just as the district court would. And so you would bring that motion and say, hey, judge, under this particular case law, specifically the Fourth Amendment, that was an illegal search and seizure of this property that is being used as evidence against me in this crime, so it must be suppressed. And then from that point, if there's additional evidence that was seized, that additional evidence in later searches, if it was derived, the information was derived to do those searches, could be fruit of the poisonous tree. And that could also be suppressed through that motion work.
So let's go back to you being in my house or somebody being in my house. Let's start with a warrant situation for a moment, if we might. You come into my house thinking that I am growing marijuana, and you don't find marijuana, but I happen to have a dye pack that exploded on my table and a bag of money from a local ATM or a local bank robbery. Do I get a pass? Do I get around this particularity situation that they require for the warrant, or how does that work?
Well, the officers at that point in time, if they have a valid warrant to be within your home, they are legally within your home. And they can search any areas of your home where that growth of marijuana would have been. Growing marijuana generally is probably big, right? Looking in rooms and probably not looking in envelopes necessarily. So the area of search would be rather large. But under this scenario, they walk into the house, they see the dye pack and the money and what is in plain view as clearly being the proceeds of a robbery. At that point in time, that evidence can be used against you. It can be seized.
And you used some interesting words there, plain view. That's part of the search and seizure doctrine, right?
Right.
That the courts developed.
Yeah,
this
that's a
whole
recognized
plain view
exception.
idea?
Yeah, that's one of those recognized exceptions.
What has to be in plain view?
So the way that courts look at plain view is, number one, the first question is the officer lawfully present? That's what Mike was talking about. So if the officer is not lawfully present, then it's not plain. It's not a recognized exception, right? The next one is it immediately apparent? What courts do today, they basically, what that means is, did the officer develop the probable cause without manipulation? So if the officer sees, an envelope, and he's not supposed to be looking in the envelope anyway under the warrant, and looks in there and sees stolen checks, that's not plain view. That's manipulation. So is it immediately apparent? And then the last thing that they normally look for is, does the officer actually have a right of access to the item itself? So, if you see, if you're walking by a car and you see evidence in plain view, that doesn't necessarily mean that that's the reason you get into the car. The motor vehicle exception can get you into the car, but some states don't allow that. Some states require a warrant with those facts. But the point is, those are the three things I think courts really look for under plain view.
And so plain view, I mean, it's kind of interesting because I would assume there's some factual debate over what view is plain, if that makes sense. So our scenario with a home with a trespass sign or without a trespass sign, I've got marijuana plants growing in the front yard or the backyard.
Okay.
Backyard's even better. You have access to the door. I don't have anything that says that you can't come into the yard. You can see them through my chain link fence.
Right.
That might be plain view.
Yes.
I've got a 12-foot wall and no trespass signs, and you bring a ladder from Home Depot to take a look over the top.
That's, with those facts, that's not plain view.
Not
That's a search under the Fourth Amendment.
That's a search under the Fourth.
Correct.
Through a window?
It depends on where you're at. Are you on the sidewalk?
Okay.
Right.
So that's very interesting, right? So a home might be different than an apartment, for example, where you've got an open corridor and if you look through a window versus walking through a yard,
Right.
you might get a different level of protection. Is that fair?
That's very fair, yeah. I mean, apartments rarely have curtilage. They can. They can in unique, but they don't really have curtilage. They have just their boundaries.
How does that work with technology again? We've got, we can see through walls, right?
Right.
We are so advanced we can see through walls now with infrared technology and things like that. Can you do that? Is that plain view?
No.
It's almost like the Jardines thing, right? With the dog being able to smell inside the house. If you have some sort of device that can see inside the house, right, that's a search.
Right.
Even if you're located out front
And
of the house.
there's a case on that too, which I don't know if Kylo. I think it's Kylo out of it came out of Oregon, but it went to the U.S. Supreme Court. But the way we resolve that, which may be a good opportunity to talk about, is what is a search? What is a seizure under the Fourth Amendment? What if you don't have a search or you don't have a seizure, you don't have to be reasonable. You could tell the judge, I did it because it's Tuesday. But if it's a search or seizure, you have to be reasonable, and now it requires a justification.
How does that work with, let's talk about utility bills as an example. Would that be enough to search? I have a utility bill that is wildly disproportionate and you think I've got a grow house, for example. Can you search those? Are they public record? Do I have some kind of privacy right? How does that work?
Well, it brings up the third-party doctrine, but if you're asking, is a high utility bill, electric bill, for example, that's consistent with a grow operation in and of itself enough for a search warrant? I say absolutely not. But
Yeah, I would say not, but it could be something that is considered in furtherance of
right,
probable cause.
it's pointing in the right direction.
Right.
So it's a piece.
It's a piece, right?
It's like it sounds like a jigsaw puzzle to some
Right.
extent.
Well,
Sure.
if that
Scrabble.
the high utility bill comes in, right, and then some police officers go outside and just sit surveillance on the house in undercover cars, and they see these huge bundles coming out of the house that appear also to be consistent with marijuana grow operations. At that point in time, I think that you've now added another piece to it and increased that base layer of evidence, that slight or marginal evidence necessary to establish probable cause.
So I wonder in practice, and I've seen this a bit, if there is a chance that sometimes the exceptions might overtake the rule, if that makes sense. Is that
It can
Is
happen.
that part of what the court struggles with?
I absolutely.
And I'll give you an example. Years ago, I represented somebody on a drug trafficking case where the declaration said he was going to a city known for high drug traffic,
Right.
Salt Lake City. That was exactly
Right.
my reaction at the time. If could be, but I mean, any metropolitan area, that's kind of a generic
Sure. A high
claim to
area,
justify what's going on.
Right.
I think, is the word pretext that we use in that situation, or is that's the argument that a defense attorney would use, right? That it's pretextual, that you're making up a reason to support one of these pieces you are putting in, you may be putting a round peg in a square hole.
Sure. I mean, but I'm wondering, are they, with your whole, they went to a known drug city? Was that the reason for the stop itself?
That was one of the facts listed in the declaration for affidavit to pull somebody off a bus.
Then
They
I
were
wouldn't be.
traveling to and from.
I don't think that would be a pretext. It's the reason. It's the text. It's the reason that they're doing it. Pretext usually means that, right?
Well, yeah. So it's well, I suppose that's a question. Do you think traveling to by bus to Salt Lake City is actually a reason to go through somebody's luggage?
I think we all can agree that that's not enough.
Right. So and that was kind of my point when I said pretext. Some of the times we can
Gotcha.
stretch facts a bit to fit things to try to get by. I think you said some judges are rubber stamps.
Yeah, rubber stamp judges. Yeah.
Yeah, for lack of a better
Term. Yeah.
description. Yeah.
Yep.
How does this warrant requirement? We've talked a bit about automobiles.
Mm-hmm.
Automobiles are a really unique and difficult area. Tell us a little bit about that.
Well, I think the first thing we got to know is that the motor vehicle exception is the most powerful warrantless search done by law enforcement. And the reason why, it is the only search that cops do as if they had a warrant. The case there is U.S. versus Ross. But if you think about all these other warrantless searches that police do, search, incident to arrest, protective sweeps, inventories, they never conduct those searches as if they had a warrant. It's always limited. They always, search and arrest has a lot of limitations. But that motor vehicle search, as it is right now, is an extremely powerful search. They can physically tear apart the car without a warrant. They can do damage without a warrant, as long as they had the probable cause. So it's a very, very powerful search.
And that's the key, is the probable cause before the search.
But probable cause for what? If I'm speeding, can they tear my car apart?
No.
There'd be no evidence of speeding.
There's no evidence of speeding, right? So evidence for narcotics, open container. I mean, there are cops who will see an open container in the car. The question is can they search for more open containers? The answer generally is yes, but they do it in the manner as if they had a warrant. Would a judge allow the cop to search the trunk? No, because in Nevada, it's not illegal to have an open container in a trunk. So if that officer, with those facts, goes into a trunk and sees a gun, drugs, whatever, that evidence should be suppressed.
So having a closed container of some sort might change the context of whether or not it could be searched?
No, not under the motor vehicle exception. It can even be locked under the motor vehicle exception, and cops could, force it open. I think we both agree. If we're breaking things open, cops probably should get a warrant, especially for big cases. I mean, the motor vehicle exception is very powerful, but
So give you an example with the what I'm thinking about with a lock situation. You're looking for a firearm of some sort. I'm an ex-felon, and somebody says they've seen me with a gun, and it's not just a random citizen. That might be an issue,
Yeah, you
right?
have a confidential informant, something, right?
But somebody that can be verified, not just a phone call.
Gotcha.
Right? Could they tear apart my ashtray looking for the gun, or would that be beyond?
So, I mean, I think the way that some of those situations have worked out, where the police officers have developed probable cause to believe that there's a weapon inside the vehicle and the person's not allowed to possess that weapon under the law, is that when I've seen it in actual practice, it's come into play where the officers begin their search and they do their vehicle search, and then they'll maybe touch the side panel of the vehicle, and that side panel is loose. Something that indicates that it's been tampered with, and usually it's just a quick pull-up of that, and there's the gun. And so oftentimes there's no breaking involved. But, yeah, I mean, they could.
But to seize it, they have to have probable cause in the first place, right? You can't just take my car from me and go dig through it without the probable cause.
The probable cause has to come first. Under the motor vehicle exception, there's generally 4 things that I think cops are looking for. Number 1 is probable cause. The probable cause defines the scope of search, right? Probable cause for a open container is a very limited search compared to narcotics trafficking. The next thing is, my friend who mentioned curtilage. It cannot be on curtilage. That's a U.S. Supreme Court case called Collins v. Virginia. We can't go onto somebody's curtilage and search the vehicle under the motor vehicle exception. The other thing is that the vehicle has to be readily mobile, right? If the car is on 4 bricks, that's a problem under the motor vehicle exception. And then the last one is that you search it in the same manner as if you had a warrant. So you have to think about what the judge would allow you to do.
Why does the mobility of the car matter?
So the mobility of the car really doesn't matter, not in 2022. It mattered in 1925. The motor vehicle exception came from a case called Carroll. And in that case, the U.S. Supreme Court talked about how the mobility of the car justified the intrusion into the car because by the time the cops came back with a warrant, the vehicle may be gone in another jurisdiction. But I got to tell you, Carroll was kind of based on exigency. I think there was legit. If you actually know about Carroll, there was exigency there. But since then, there's other cases that have come out, and the Supreme Court has been very clear that real exigency, like the car is going to go somewhere before we get a warrant, is not required. Period. End of story. So the idea that it's mobile helps kind of justify why we search cars. But in my view, the real reason why we search cars like we have a warrant is the reduced expectation of privacy on cars.
I'm just thinking. I mean, with the problems that we have with poverty and other things, what about somebody that lives in their car?
Well, that's kind of one of the readily mobile things, right?
Yeah.
If somebody lives in a vehicle and, it's clear that it's just being used for that purpose, that they're just using it as their home, that could change the factors, right? If all the tires are popped, it's not readily mobile, right? And
it has like a porch on it or something. But we got to be careful here, though, because there is a U.S. Supreme Court case called California versus Carney, where Carney was living in an RV that was in a parking lot in California. And so this is his home in every meaning of the term. But it was also a readily mobile vehicle. And the police searched it, and the U.S. Supreme Court upheld it. They said that, look, it's either one or the other. It's either a home or a car, but it can't be really both because they get treated differently. And if the person, here Carney, is using it also as transportation, they're going to side on the side of that. In this instance, it's going to be a car.
Is there? This sounds very technical and fact-driven. If you are a police officer and going to do a search, it sounds very, I'm not going to say onerous, but you have to know a lot.
You do, yes.
You are playing the odds, kind of like playing blackjack or roulette, it seems like, and if you make a mistake, your case goes away.
Yep.
Is there another simple way to get around this? Because I think what happens in most of the cases that always shocks me as a defense attorney is, can I search your car?
Right.
And the person says,
yes.
Yeah. Consent, right?
Right, good old-fashioned consent.
How does consent work with this?
Consent's always an exception as long as it's voluntary and it's not coerced, right? So if somebody decides, yeah, I'm going to allow you to search my car knowing full well, right, that they have drugs or a gun or a dead body in the trunk, then, they gave the consent. They essentially waived their Fourth Amendment right.
Boy, if I'm the person not wanting to give consent, I know I've got something bad in my car, and you've stopped me for speeding. And you say, can I look around your car? If I'm not a trained lawyer, I'm doing this sort of thing, right? I'm weighing back and forth whether I should say yes or say no, because I have to think in my mind, if I say no, I've just told you there's something I don't want you to see.
I guess it's the same logic for Miranda. When somebody invokes
Yeah.
the Miranda, they're hiding something. But consent is always part of it's always a right that people have. Some people think that cops asking for consent is inherently coercive, but it's not fair for the government to be considered coercive simply because they wear a uniform. This is what they are tasked to wear, and they just ask people for their consent. I think maybe there's a level of persuasion there, naturally, because that is a police officer, but police officers do have to be very careful not to cross any lines, not to make any threats, not to, we look at things like surrounding the person, maybe subconsciously having a hand on a tool like a gun or a taser, but consent is a valid way to search. Legitimate.
If the police pull me over to issue a speeding ticket, and they are suspicious, but they don't have probable cause, they can develop it during the stop.
Right.
How long can they do that? Can they hold me for hours? I've got
Not in
tickets to the
Nevada.
Rolling
No.
Stones tonight.
Not in Nevada.
It's 60 minutes, right, in Nevada, as long as there's reasonable suspicion for the crime, that a crime is occurring. And then we have further case law, Rodriguez, I believe, that indicates that really the officer needs to complete the purpose of the stop originally and that investigation. And if the stop is extended beyond that point without good cause, without reasonable suspicion to believe there's a crime occurring, then that could potentially be a big issue.
Go ahead.
So, Nevada is a unique state in that it's the only state that I'm aware of that it has a 60-minute rule. No states, and certainly not the federal government, has a 60-minute rule where the officer has to develop probable cause within 60 minutes. If not, the person has to be released, or it turns into a de facto arrest, an arrest in fact. The other thing I want to share with you is that you brought up pretext earlier. Pretext traffic stops are controversial. Sometimes people think that pretext means racial profiling or something like that, and certainly that is absolutely prohibited under the Constitution. But one thing is that if an officer is going to make a traffic stop, and they have this hunch that the person may be involved in other criminal activity, let's say guns, drugs, stolen property, and they pull them over for running a stop sign, the one thing that the cop does not get in 2022, based off Rodriguez, is a free gun, drug investigation in addition to this running the stop sign. They cannot extend the traffic stop to chase down their hunches, not by extending the traffic stop. They can't do that. And so that is one of the biggest issues that officers are trying to balance. Like, how do I ferret out crime? How do I protect my community? How do I get illegal guns off the street and drugs and so forth, but also not violate anybody's rights, obviously, right? So there's a little bit of a balancing act there.
And it's interesting that you mentioned that Nevada is specifics. So we talked about MAP in the introduction versus Ohio, and that applies the Fourth Amendment to state actors. But the states can give more rights or more protections than the federal government does if they want it?
Sure, under their own law.
Okay, and Nevada's actually got a search and seizure clause in our Constitution, correct?
It does.
Yeah.
But rarely does Nevada make things more strict than the U.S. Supreme Court. The 60-minute rule is an example. There's also a Fifth Amendment. Nevada's more restrictive on a couple things than the Fifth Amendment. But generally speaking, Nevada is in line with the U.S. Supreme Court.
And I think at one point we had a would versus could requirement that was debated in federal court. Would the officer conduct this stop versus could?
Correct.
For example, driving over a fog line, normally an officer might not do a stop.
Correct.
But they think you're a bad guy, so they look for a
could.
reason.
That's a U.S. Supreme Court called Wren. I think 1999 or 96, but the point is that the U.S. Supreme Court adopted a could standard. If the officer could make that stop, then it's lawful. As long as it's not for ulterior motives that are prohibited by the Constitution.
And I think Nevada's on the could standard now, but for a while it was on the would standard, right?
I think
I think all Bryants are
Yeah.
all,
I'm not.
yeah.
Yeah, and that's something that has come into a lot of cases, including Supreme Court discussion within their cases, is that traffic stops are something that, every single person that drives a vehicle can be subject to. And there's also been consideration, I think it was Justice Ginsburg that talked about that in one of her dissents or opinions, that this is something that any one of the Supreme Court justices could have at any point in time
They can get
themselves,
stopped.
right?
Right.
Yeah.
And also takes into consideration that there is not nearly enough police officers out there to stop every single traffic violation that occurs. So there's going to be some that don't get stopped and some that do.
Some discretion.
Well, I think of a large trafficking that I'm aware of where the stop was made because the person was doing the speed limit, and the stop was for not keeping up with the flow of traffic.
Right.
And my thought was, what's the person to do?
I know. It's.
If you keep up with the flow of traffic,
I know.
you're going to get stopped, and if you do the speed limit, you're going to get stopped. That can't be the rule.
The policy behind that is crazy, right? To think about that because the one person is following
not
the speed
violating the law.
limit.
Yeah, you get punished for not violating the
Yeah,
law.
come
No,
on.
that clearly, that's clearly not good case law.
Yeah.
So we had some questions from our viewers, and they're usually fairly enlightening. One of them asked, why does the court suppress certain evidence outside the presence of the jury? Why isn't it a jury question?
Because the whole purpose of it is so that it never gets in front of the jury. Because if there is illegal evidence that's illegally seized, and the jury knows about it, then there is the potential that could taint the whole jury, and they can't put that out of their mind, despite.
Yeah, you can't forget what you know.
Yeah, despite being told by the court, hey, you can't consider that. That is a possibility, right? So this is a legal question, and questions of law are determined by the judge. Questions of fact are determined by the jury. In this particular instance, an analysis of the Fourth Amendment to a particular search or seizure is something that the judge has to apply the law and determine what is all these over 200 cases of the Supreme Court and all the cases in the state of Nevada addressing the Fourth Amendment say about this particular search and seizure.
So we talked about automobiles, and I was thinking about the Fourth Amendment in the abstract, and it says the right to secure their persons. Does that mean an arrest is a seizure of some sort?
It's a middle ground seizure, right? I mean, it's you got detentions and you got arrests and you have the death penalty is a seizure, and obviously the ultimate seizure. I mean, I guess in some weird way, but yeah, that's definitely a seizure.
So arresting me, I could make a Fourth Amendment challenge, perhaps.
Yeah, sure.
And a bad arrest might not, if you find something on my person.
Right. Then that would be the fruit of the poisonous tree, because that would be an illegal stop.
And we're back to the exclusionary rule.
Right.
Perhaps.
Yep.
How does that work with officers' safety? I mean, officers have got a tough job. They are confronted with people who are out of their head, either because of some kind of organic problem or some kind of ingested problem.
Right, sure.
Or
They
criminal
carry-
problem.
Or criminal problem.
Yeah.
They carry weapons. There are all kinds of issues. How does that work? Does an officer have to have a warrant before he can check to see if I've got a knife in my pocket or a dirty needle or that sort of thing? Or how does that work if he's got another reason to arrest me?
So the U.S. Supreme Court has a standard for that. It's Terry versus Ohio. They allow officers to conduct pat-downs on suspects that they have detained. Obviously, we're not talking about people that are just consensual encounter, right? These are people who have been detained by law enforcement for traffic stop, shoplifting, and all the officer has to articulate is reason to believe that the person could be armed and dangerous. It's not, in reality, it's not a high standard. It's just that these are facts and circumstances. This person could be a danger to me while I'm conducting my investigation. But it is a standard. There is this, I call them insta pat downs. That just, some cops may feel like they have that concern for their safety. If they get a person out of the car, for example, they instantly pat the person down, right? And then you tap them on the shoulder, theoretically, figuratively, and say, hey, why'd you pat this person down? And they say, well, if I'm bringing him out of the car, I'm patting him down. I'm like, time out. That's not how this works. You need articulation about why you think he's a danger to you. You don't need a lot, but you need something.
And to that, you need the reasonable suspicion that they are armed and dangerous, right? But before that, you need that same reasonable suspicion to do the stop and detain them. So a police officer can't just stop any person just to pat him down because they say, it looks like that guy has a gun on him.
Or is a gang member or something like that.
Unless there's some actual reasonable suspicion that there is a crime going on.
So putting these two things together, my car is legally parked right now in the parking lot outside the studio. If an officer has reasonable suspicion to think that I've done something wrong, I've got narcotics in my pocket, whatever it might be. It's not a confession, by the way.
Okay.
If they arrest me outside the studio, can they search my car automatically? Does it extend that way? Does that make sense?
It definitely makes sense.
Right.
So the question for me is, does the officer have probable cause that there's more evidence of your crime in that vehicle? If the answer is yes, then the motor vehicle exception comes into play. However, just because you have a vehicle in the parking lot and you have been arrested for some criminal conduct or a warrant does not give an officer an automatic right to go into your car.
So if I'm arrested, they can't just come into my house willy-nilly and look for other things unless they have independent probable cause that they might find something in the home?
Negative. Now you brought the home into the equation. So the car is covered under the motor vehicle exception. If let's say you're arrested outside your home, right?
Right.
And the officer has probable cause that there's more evidence inside your home, that officer cannot go into your home unless they either have your consent, which you may give, or they have a recognized exception. But all recognized exceptions that deal with homes, all of them are fundamentally require urgency, emergency. Let me give you an example. So the cop, you get arrested for narcotics.
All right.
Your spouse comes out and says, hey, honey, I'm going to go destroy the drugs while you're getting arrested. That would create the exigency. The officers could go in there and at least secure the premises and lock it, and they call it freezing, but freezing it for a search warrant or a warrant. So that's a good example how the home is always treated more strictly.
So they could stop people from entering and destroying evidence.
That's easy.
But they couldn't necessarily go in and seize my hard drive or whatever it might be without
even cops going in just to freeze it, just as a matter of routine. Let me just, the way to lock it down. They shouldn't even be doing that. They should not be stepping 1 foot into your home unless they have an articulable reason that there's something that they could lose in the meantime. Evidence. Now, if there's people in the home and it's a drug warrant, I mean, I can probably articulate that. Give me the facts, right? That they could destroy the evidence in the meantime.
Sure, you hear a restroom flushing.
Oh, absolutely.
Right,
And can I just say one more thing?
Sure.
Remember, when it comes to the home, no matter what, even if we do lawfully get into that home, it's never permission to search that home. It's only permission to, plain view always applies, but it's only permission to just freeze it while you go get the search warrant. But the car you could search.
So the idea, I suppose, with this warrant requirement is to have some kind of independent third party.
Right.
Look at things. Somebody watching the watchman.
That's right.
Yeah.
That's right. Somebody neutral, detached, no skin in the game, is not favoring the police, not favoring defense, just saying, hey, I represent the court system. I am neutral here.
What happens with I just think of what we talked about, victims getting a pass sometimes with these search and seizure issues, but honestly, a lot of search and seizure issues, I'm not going to say victimless crimes, but they are related to narcotics, stolen property, crimes where not somebody's been injured.
That type of, right.
Let's put it that way. Back to our drug situation. You have a warrant, you come into my house, you find drugs, and you find $10,000 in cash that you can't connect anything. Mm-hmm. Would the officers normally take the money also?
Normally, it'd probably be included in the warrant if this is a drug warrant.
No, but is it a drug? Is it a drug like dealer, trafficking, manufacturing warrant? Or is it a possession warrant?
Let's assume that it is.
Yeah, then the money's probably going, especially that kind of money. That's not like a jar full of change money. That $10,000 is indicative of a drug trafficking lifestyle.
Yeah. And you would believe likely the police officers who've actually done the investigation to get the warrant itself have the background on you as the drug dealer to know, okay, he doesn't work anywhere.
Right.
There's he hasn't inherited any money recently. So to me, seeing this, even if it's not in the warrant, it has the immediate appearance of being illegal proceeds.
And that's plain view.
Do the police get to keep that money?
Yes, yeah. If they use forfeiture statutes on the books that indicate that, if that's money that is the proceeds of a crime, then there's no legal right to it, and that can be forfeited.
But whose word is that? I just sold my boat last week, and somebody paid me $10,000 cash, and I've got my cousin Johnny to come in and testify as such.
So that would be something that would be subject to forfeiture proceedings, generally outside of the criminal case itself, but though if there's a criminal conviction, that could be used in the case, and where a judge would make that determination.
If the evidence got suppressed, the warrant was bad, there weren't exigent circumstances, whatever it might be, might the police still try to keep the money?
Potentially.
Even if I've not been convicted of a crime and even on a bad warrant?
Well, there'd still be an issue where there'd be no right to the money itself or the instrumentality of the crime.
But it's also, I think, the other problem here is that the exclusionary rule is only for criminal trials.
Right.
And that's what I was hoping to get to. Mm-hmm. So the exclusionary rule might protect me from going to prison, but it might not protect my ill-gotten gains or maybe even my legitimate gains if somebody can civilly claim that there was some kind of criminal activity.
Yeah,
and it's connected.
It's like this, for example. I mean, to take it beyond money, let's say there's an illegal search that involves the seizure of child pornography, right? So though it turns out that the evidence is suppressed and can't be used against the defendant in court, there's no way that that defendant is going to ever get back those images of child pornography.
And I will say, as working as a defense attorney for 25 years, I think the hardest thing I ever tried to do was get $130 back from Metro for a client involved in a stabbing that had nothing to do with the money. It's the civil aspect of things is just very nebulous, complicated, hard to deal with.
And also I think this is not my domain,
Sure.
but one thing too is that the standard of proof is a lot lower. I mean, in his world, it's beyond the reasonable doubt. In the forfeiture world, am I mistaken? Is it clear and convincing here?
I believe it would be clear and convincing, but it's also not my expertise.
But it's not beyond a reasonable doubt. It's either preponderance of the evidence, right, which is like 51%, right? Or it's clear and convincing, which is between that and beyond a reasonable doubt. But that's another issue. That's one thing that is in favor of the forfeiture statutes, and it makes it a little harder to get the $130 back.
Yeah. So I was, we are lucky enough to live in the vacation capital of the world, or close to, right, here in Las Vegas.
Yep.
And there's been a lot of talk about the protections I have in my home. What happens if I run a room at Caesars?
I love this. So hotel rooms are quasi-homes, right? They have, what I like to say is they have real world, they have protections like a home, but they do have some real world limitations. Things like you can be evicted. I like the word ejected, just like thrown out. Because evicted implies a tenancy. You're not a tenant at the Caesars, but you are an occupant. And so for example, if you're at Caesars and they want you gone for something, we call it good cause in the Ninth Circuit. Things like fighting, partying, fraud, they can eject you. And the police, can help eject people from the room.
And that's something that it's interesting to think about in the concept of hotels, and especially as we sit here today, it's October 1, right?
I was thinking the same thing.
And so, we know that being in Las Vegas after October 1, we've seen a lot of things change in this city, and it's something that we're never going to forget, right? But one of those things that's changed is some of the security procedures that are in place in these hotels, including maybe scanning bags through x-rays, having certain devices that are checking people for guns as they're coming in without them even knowing,
Well,
and potentially doing room searches, right? And these are things that are done by a private entity and not at the behest of the police.
So no Fourth Amendment issue.
No
Right.
Fourth Amendment concern.
And I suppose the argument is, if you don't like it, go someplace else.
Right. And
or
because
sue, right? I mean,
sue.
if you feel like you've been trespassed upon, right? If your room is illegally ransacked, then yeah, you could there's probably a civil claim there.
and more likely than not, that is just part of your license as you're invited onto the property for your limited stay there as a
Right.
guest.
I think of some of our, the stars that we have living in Vegas, some of the exotic animals and things. Suppose I have a tiger in my room, and a maid sees that and reports that.
Right.
Do I have any protections? I don't, I suppose, right? I mean, it's my room, but to some extent, absent.
Yeah. No. That maid can report that, right? She's gone into the room for a business purpose, to clean your room. And that's the reason why she's there. She's not going in there as an agent of law enforcement. And so at that point in time, if she were, right, if the only reason why she was going into your room is because the police said, hey, you're a maid, just walk right in there and search this for us, that would implicate the Fourth Amendment. But here, she's going into your room to clean it, and she almost gets mauled by your tiger. Yeah, that's going to be something where it can be reported, and then you can be invited. Law enforcement can be invited.
And I think about the hallways that we've got. I mean, we've got surveillance every place in Vegas, particularly after October 1. Those videos, you don't have an expectation of privacy there, right? If you're doing something nefarious in the hallway.
Well, even if you're not doing something
by the door.
nefarious, it's still no privacy. I mean,
Yeah.
the facial recognition software and their so they can do what they want with that.
So, but private entities can do a lot of things that the police can. I know one of the cases that we'd talked about before we sat down today, or that we'd emailed back and forth about, had to do with putting a GPS sensor on a car.
Right. So that's this is an important case because it actually helped define, or maybe even Mike talked about how in the 1960s things really changed. The courts were looking at trespass, but in 1967, is it 69 or 67? But it turned to the court also established reasonable expectation of privacy. So this is CATS. This is what I call a telephone booth case. This is where the government was listening to phone calls. But really what happened is CATS took over. Like pretty much every court was just looking at things through this CATS lens, the reasonable expectation of privacy lens. And trespass was mothballed, but it got resurrected in 2012 in Jones' case, where the federal government put a GPS tracker on Jones's Grand Cherokee. They tracked him for almost a month, no warrant. And they finally got a warrant after the tracking information and found about $1 million in drug money and 92 kilos of cocaine. And the U.S. Supreme Court unanimously said that was a search. They disagreed as to why. Some thought it was an expectation of privacy issue, but the majority opinion said that the touching of the car, the trespassing onto his car with the intent to gather information was a search under the Fourth Amendment. And I got to tell you, that case has had very interesting ramifications around the country because cops touch protected items all the time to gather information.
The touching is a very interesting aspect, right? Because another thing that we see here in Vegas are traffic lights, traffic cameras.
Right.
There's traffic, particularly on the Strip,
Yeah.
particularly after the Lakeisha Holloway situation at the Paris in Christmas. There are lights, there are cameras everywhere. Could the police track my comings and goings with those if they didn't touch my vehicle, or is that like GPS? How's that work?
So the way I see that, and the way it currently exists, is that those are out on public streets, right? And so you're on a public street, I'm on a public street, I see you on a public street. You have no expectation of privacy there. The cornerstone of the Fourth Amendment, right, as we have it, is reasonableness. Is it reasonable? And so is it reasonable to believe that you have an expectation of privacy on that street? No, it's not. So a camera being out on a public street like that, that's something that I don't see as implicating the Fourth Amendment in itself.
I'm going to say that right now, as it's deployed, no. But I will say that because Vegas is an interesting city where practically every intersection has a camera. And we also have front license plates in Nevada. So if you could insert the software into the system, you could literally track people around the city because you can read front license plates and so forth. And it turns into a virtual GPS. I'm going to say that I think that a court can be convinced that if you, and there's a few factors, right? How long are you keeping the information? Are you purging it after 10 days? Or are you just keeping people who are registered sex offenders on parole and probation? Or are you keeping everybody? You're keeping indefinitely. But I think that there is a scenario where those cameras do turn into a search. But we're not even close to that yet.
And it's interesting. I mean, I've got a 17-year-old driver in my home who just recently started driving. Yeah. And it's stressful. He does a good job, but I track where he goes with my phone app, which we couldn't have done some time ago. And I suppose that's kind of like the GPS if they subpoena whoever the car company is, GM or Ford or whatever it might be. That might present problems for that tracking information, but that information is available against all of us, right? I mean, to some extent, depending on
not
what's
without
out there.
a warrant.
Not without a warrant.
Right, not without a warrant. So that's not something that could be like a court order and just get, or even just go and ask for it. This is something that is going to implicate your private comings and goings, your private dealings, and the Supreme Court's ruled that you need a warrant.
And even if I don't have a car, even if I ride the city bus or I'm on foot, we all keep these magic little devices in our pocket.
Right.
And if you wanted to and had the wherewithal, I've seen it happen in many cases, they can track where you're at.
Sure.
Right?
Sure.
If they've got reason to find me. Now, luckily, it's helped us find a lot of people that are really dangerous.
Right.
But the flip side is, without this warrant requirement, they could track any of us at any time, and a lot of us might not like that.
Right.
Right.
So it's an interesting. It's an interesting conundrum. I'm going to give you guys an opportunity to chime in as we start to wind down, but I do want to talk about one of those things that's I think on the forefront of this, which is social media, because social media presents all kinds of other issues. That same information that I've got for my son and where he goes. If somebody who's tracking Elon Musk's plane recently, right? There was somebody Elon Musk had offered to pay him not to track where he was going. It's like an 18-year-old that had tracking information, was all on public information. But if I post where my car goes on Facebook and I have an open account, or I post myself with narcotics on Facebook, although I guess it's hard to test and there's a lot of phony things in pictures, but whatever it might be, do the police generally need a warrant to look at my Facebook page, that sort of thing? Does it depend on whether it's password protected or whether we're given access? How does that work?
So if you post you with narcotics on your open Facebook page, and once again, we go back to that cornerstone of the Fourth Amendment, the reasonableness standard. Do you have a reasonable expectation to privacy in that photo of you with narcotics on your open Facebook page that is available to anybody in the entire world, just with a computer? No, definitely not. So because of that, law enforcement can just log right in and look right at your Facebook page.
And are we getting to the point where Facebook and those kind of things are being used in court entries and
yes,
and whatnot?
We actually spoke about a case rose now out of the Ninth Circuit very recently that's also, it presents an interesting concept, is the actual provider of the service, Facebook itself, doing their own searches and maybe even searches of confidential or private information that you might have locked behind a wall, right? That only they can see, or in your private messages, that violates their terms of service. So at that point in time, if Facebook comes upon information within your private account that violates, they're searching for the reason to determine if you're violating their terms of service, but it also implicates you criminally. They can turn that right over to the government, and that could be used against you.
Right. And we see that with text messaging too, right? I mean, a lot of the cases that I handle anymore, one of the first things that happens is the phones are taken with a warrant, and there's a phone dump, as we call it. They do the information, and they look to see if there's texts back and forth that are threatening, that give some kind of motive, whatever it might be. I suppose, not that we want to teach people how to skirt the law, but I suppose the takeaways are if you give consent, you're going to be stuck with a consent, and if you put it on Facebook, you're going to be stuck with what's on Facebook.
I think that's a good message.
Yeah, I mean, if you want to try to ensure that you're the most private person possible, and then you might as well just retreat to a home in the middle of nowhere.
Become a hermit.
Yeah, without any access to public utilities, so there's no information going there, without any cell phone, without any internet, and hey, the police can't come into that private home of yours right in the middle of nowhere, and they're going to have no information on you.
Well, this has been a enlightening discussion, gentlemen, and I want to make sure I give both of you the last word concerning search and seizure. What final thoughts might we have?
I think that here I appreciate you and I appreciate our Nevada judges for having me here. I would note that any views expressed today are mine solely and not those of the district attorney's office. And with that, the Fourth Amendment is the most important part of our overall criminal structure and keeping the government accountable to the people. And here we have some case law over the decades, over these centuries, that has been developed and will continue to be developed. And what is so interesting about it is we sit here today with looking at the Fourth Amendment, talking about cell phones, talking about the internet, something that our framers could have never imagined 50, 100 years from now. This is going to be something that is going to develop way beyond what we could even imagine now. And so it is always changing and adapting to the way society is, and it's an amazing thing. It's one of the reasons why I love the law.
Mr. Bandiero?
Yeah. My lens is law enforcement, since I train law enforcement, but one thing that I'm extremely happy about is that I'm on the cusp of really helping cops embrace this legal training and actually take it as seriously as they have their physical training. What I like to say is their physical training, the running and gunning stuff, the things that all cops kind of like to do, but that's their physical survival. What I train them is their legal survival, so that it helps put away bad guys, but it has to be done the right way. And I'm very fortunate because with the training that I've provided, the reception has been very overwhelmingly positive, especially in the Valley, Metro, and Henderson, and North Las Vegas, NHP. They've all been really they want to learn all these things that we've been talking about today. So that says something. I mean, 40 years ago, can you imagine having this conversation with? They'd be like, so.
Yeah, I love the forum too. It's a great opportunity for people from both sides of the aisle to sit down and have an open discussion about things where we're not fighting like we might be in court.
Yep.
I want to thank you, gentlemen, for coming, and you've got your work cut out for you in a very difficult and evolving area of the law, particularly as technology moves. Again, thank you for being with us.
Thank you.
Thank you.
This has been our Nevada Judges. I'm Scott Coffey. Until next time, have a good day.
There you are.